Everything will go, Maharaj. No adjudication. By the mere act of recognition relating back either to 1990s or to 2000 and 19th of July or to 23, 21st of June, there would be chaos. The consequences are, and apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next point, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a lordship of Rajendra Rana. Now note this, note this. Not a single judgment even of any high court, leave aside Supreme Court, says that the election commission will relate back. A constitution bench has held the field for very long, saying a disqualification 10th schedule order relates back. If your lordship were today to do this, your lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a constitution bench to relate back. And your lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, suppose tomorrow the speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to June 22. But there cannot be disqualification because by then your lordship also would be applying a EC order retroactively. Therefore, your lordship already has jurisprudence and a precedent.
Prospective according to you.
All right. Then, the fifth aspect is this political party and legislative party.
Yes. Dr. Singhvi, now 5 minutes now.
We will finish before lordship's time. Within this time, we'll finish. We are conscious of that. 3:45 minutes, we'll finish within time. I'll give him 5 minutes also. He'll have 5 minutes. Now, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibal's. This is very different. Kindly read this from a different perspective.
F, right?
Yes, F. Starting para 35, page 12. Members of a legislature party do not have any right to act contrary to the directions of their political party. This is the heart of the political party, legislative party debate, with which Mr. Kaul also started today at 2 o'clock. As per 194(1), the freedom of speech is subject to the provisions. I pointed it out already. Under 170(1), the assembly of a state consists of members. The members are elected by direct election from territorial constituencies, and the nature of the election process is such that an elected member set up by a political party has no independent identity in the house except as a member of the political party. Well, actually, in practice, how we sit, where we sit, which rooms we are given, is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10th schedule, prior to 85, the constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. Even though political parties were always recognized to be an essential component of the Westminster form of parliamentary government, political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the 2 statutory levels. It came in for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, our lordship has been asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party, by its very nature, is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And well, as your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislature party is used. First, in 2.1 it says, a member of a House belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition. Then, Malas, there is no mention of legislature party in para 2. None. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislature party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the fraction of 1/3 goes below. In para 4 too, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it is described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. If no defense is claimed, the legislature party has no constitutional or legal relevance, is para 43. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument, dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say that's too broad a basis for your lordships to act or give any judgment on one. Dissent. I just say I'm dissenting and I leave the 10th schedule. Reliance is placed on the law of speaker, where deho the legislative assembly, disqualification rule, the president of the political party who was not a member was given the right to maintain disqualification. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto, that para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. Your lordship should not be referring, Nawab Your lordship be reconsidering Kyoto also on this basis. Now kindly see. This is a very important para, para 49 at PDF page 109. 109. Very telling para, directly the same sentiment. How do you harmonize the two, and you cannot allow one to be reduced to vanishing point? Kindly see this. And I'll end in about a minute or 2 minutes. Indeed, in a sense, may I read this, fellows? 109. This is very, very important, fellows. It's a covered field. Your lordship need not be agonized about it, as my learned friend would like your lordships to raise a new issue before. It's a covered point.
1090.
109 PDF, CJ2?
CJ1.
CJ1. Inappropriate acronym, fellows. We used to call it CL1, case law 1. I don't know where this time, first time I found CJ1. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better, fellows. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially with the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. Theoretical assumption. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. let it be within the scope of the Constitution and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances. You don't follow them, but you follow this. This is extremely unfair. This is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries. I'm extremely grateful and
Thank you, Doctor.
very deeply obliged.
Thank you, Doctor. Yes, Mr. Comment.
My lords, I had addressed your lordships on writ petition 479 of 2022, which was a challenge to the decision. Lord, that is A5. I'm sorry, my lord.
Right.
It's rejoinder, additional rejoinder A5, filed yesterday.
Yes.
Yes, my lord. My lords, I had made submissions, my lord, only on writ petition 479, which is challenging the validity of the decision of the speaker on 3rd of July 2022. That is, my lord, the change of recognition from Sunil Prabhu to Bharat Gogavle late in the evening of 3rd July. Now, my lords, the validity of this decision is, my lords, unconnected with the ultimate, my lords, view which your lordships will take in the disqualification proceedings, whether your lordships want to decide it here or send it back. This, my lords, challenge is an independent challenge. Your lordships will have to determine whether the speaker was right or wrong. And the only defense which was taken originally in the reply was that it is 212. It is inside the house. And I had said that that is completely in the realm of unconstitutionality. There has been absolutely no rebuttal, my lord. That I have indicated in paragraph number 2, my lords, item 2. 3, my lords, I had submitted sub-Roman small 3, that the term political party is not an indeterminate, nebulous concept. Today, there are 30 people claiming, there may be more factions claiming that I am the political party. But on 21st of June, there was only one political party that was, my lord, in writing, which was communicated to the Election Commission, that was headed by us. Lord, with respect, this is not, my lord, a Narova Kunjarova. My lordships are aware of Mahabharat, my lord, that Ashwatthamo Hata, Narova Kunjarova. Whether they are Shiv Sena, we are Shiv Sena. In June, my lord, still they filed a petition on 19th of July. There was no dispute, there can't be any dispute in law that I represented the political party. So that's the second point which has not been answered as far as section 29A is concerned, my lord. Now, my lords, Mr. Sibal has pointed out about the validity of the whip, my lord, and that only the political party can issue a whip, and that Erskine and May, all that was cited. And my learned friends have argued that no, it's the legislature party can issue the whip, rule 3.1, etc. The lordships have seen rule 3.1. Rule 3.1 does not deal with a whip. Neither the form deals with a whip. That is by convention. And in fact, affirmed by your lordship's judgment in Mayawati. Kindly have the highlighted portion, my lord. Paragraph 73 of Mayawati, reproduced in paragraph 3 here. Whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. This was the argument. There is no merit in this contention when the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party and prescribe that the direction issued should be one issued by the political party or by any person or authority authorized in this behalf. There is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. This is Mr. Kaul's argument, my lord, specifically rejected. Now, my lord, all this parliamentary convention which we have set out in paragraph 4, my lord, has not been rebutted. Not even one precedent shown, my lord. Now, my lords, kindly turn to Roman 3, and this is a legal submission, my lord, that having a legislative majority ipso facto or ipso jure is not suggestive of a majority in the political party. My lords, Roman 1 and 2 have already been dealt with. Now, my lords, kindly have Roman 3. In fact, my lord, there are one-member legislature parties. And in those, my lord, circumstances and facts, Election Commission has said that we have to see the organizational majority to see who's the political party. So therefore, my lords, merely saying that you are a legislative majority and therefore you represent the political party is legally incorrect. Now, my lords, reference was made to Sadiq Ali, that Sadiq Ali, my lords, affirms this proposition. In fact, in Sadiq Ali, my lord, this point was kept open and I have highlighted that, my lord. Kindly have a look at Roman 4, the highlighted portion. The present is not a case where a conflict has arisen because of one group having majority in the organizational wing and the other having a majority in the legislative wing. This is fallen for consideration here. Now, my lords, one submission was made by Mr. Jethmalani yesterday that look here, we are also members of the Pratinidhi Sabha. Therefore, we represent the political party. Lords, on affidavits in the election commission and also here, for which there is no rebuttal, out of 220 Pratinidhi Sabha members, 160 plus, my lord, have supported me. 160 plus, not rebutted. Now, my lords, kindly see the next submission which is made. And this is again Mr. Jethmalani's submission, that Quixote said in paragraph 97 that the decision of the speaker is not covered by 212 and that the rules made under paragraph 8 have a constitutional status and therefore violation of that 2-day period or 7-day period is violation of the constitutional mandate. Totally against Ravi Nayak, my lord. Not even one judgment was cited in support of that submission, but kindly see Ravi Nayak, it's covered. Now kindly see paragraph 8, my lord, the highlighted portion. The disqualification rules are procedural in nature and any violation of the same would amount to an irregularity in procedure which is immune from judicial scrutiny. Then, my lords, I just have 30 seconds, my lord, I'll just finish now. My lords, then a reference was made to some speeches, my lord, that I have dealt with. Lord, some speech of some Digay. It's totally inadmissible. My lordships have held it time and again, which your lordships have seen in Kalpana Mehta Constitution Bench and also in Shivraj. Speeches by, my lords, members, totally irrelevant, my lord, to decide what the scope of the provision is. Yes, my lord. Then, my lord, para 6, they said that mere non-attendance of a meeting will not amount to a para 21A. Specifically, my lord, this was the issue in Shriman Balasaheb Patil. One meeting they didn't attend. It was held to be a para 21A, which I have reproduced, my lords, in paragraph 14. Now, my lord, the last thing is important. Kindly have paragraph 15. My lords, time and again, my learned friends, my lord, said that we have never claimed a split. In fact, I remember, my lord, Honorable Justice Kohli asking Mr. Kaul, is it your case that there is a split? And he said, on more than, my lords, 5 occasions, which I have reproduced, kindly see this. First, our case is not a split at all. I have never argued I have a split. Now, kindly see the submissions before the Election Commission. And now the cat is out of the bag. Please have a look at paragraph 16, my lord, of my note. And I have reproduced paragraph 7 of their petition before the Election Commission. In view of the above mentioned facts and circumstances, it is evident that there is a split in the Shiv Sena. And all the written submissions filed by Mr. Mahesh Jethmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17. To come here, my lords, and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Lords, lastly, my lord, ultimately your lordships will decide. Lords, I am reminded of a, my lords, Sanskrit Subhashit, my lord. And it says, my lord, Kakaha Krishnaha, Pikaha Krishnaha. That, my lord, the crow is also black, the cuckoo is also black. Ko bedaha pika kakoye. What is the difference? Who's the Shiv Sena here? Vasanta samaye prapte, kakaha kakaha, pikaha pikaha. And I'm sure, my lords, the time of judgment will be clear, my lord, who's the real Shiv Sena. Thank you so much.